We're going to move to Robert Capers, who I'll briefly give his background. He went to NYU, undergrad, Albany Law School. Similar to Nicole, he was an ADA in Robert Morgenthal's office for a number of years, then became a federal prosecutor in Brooklyn, and ultimately rose to be the head of that office, the U.S. Attorney, in 2015. He spent, after he finished that tenure, a brief time as a partner in private practice, and has returned to the courts in 2019 as the Chief Probation Officer for the Eastern District of New York. So welcome, Rob. And if you could just briefly talk, I mentioned the pre-sentence report in the beginning. Can you just briefly explain to the teachers, people are confused because the probation department prepares that report. They're just confused, I think, by the name, but they prepare every report. Can you just, and I think a copy of the sample one was part of the material so they can look at it and page through it, but can you just briefly describe what's in there?
Sure, Judge. Thank you. And I just want to say to Mr. Williams, thank you for the powerful testimony. I appreciate that. I just want to start by saying, as a former prosecutor for most of my adult life, I believe in the notion of second chances. And that's why I came to the probation department as the chief probation officer, because I believe that the department that I run and the people that I work with are tasked with, among other things, helping those who are deserving of a second chance do their best to successfully reintegrate back into society. So that being said, following up on your question, Judge, the pre-sentence report is one of the most important functions that we in the probation department have. The PSR, as we call it, is the instrument, the chief instrument through which the judge is able to gather all the information that he or she can have, and learning as much about the defendant that's before them, offense conduct, et cetera, so that they could have information in front of them to appropriately consider what the sentence, what the appropriate sentence should be for a defendant. The difference between my job and that of a defense lawyer or a prosecutor is I don't have a side that I advocate for. I advocate down the middle for justice, and justice is determined based upon what a judge's understanding of the facts and circumstances are, aggravating or mitigating factors, whatever they may be, so that they could fashion a sentence. And so what our officers do in the pre-sentence division is they conduct an exhaustive investigation where they do everything from gather up documents and reports from the U.S. Attorney's Office, from defense lawyers, from the investigative agency, the agents from whatever the law enforcement agency is, be it DEA, FBI, ATF, or whomever, and begin to compile the offense narrative. If there has been a trial, we also go through the trial transcript so we can gather all the facts and circumstances of the offense. We then, the next phase of that is we interview all the parties. So we will interview with defense counsel present the defendant so that we could understand everything from the offense through that defendant's eyes to any and all facts and circumstances of that person's life. And we dig into everything from the time they were born until the present, all the good, the bad, and everything in between, so that we can lay that out in the pre-sentence report. And so then the pre-sentence report is broken down into different areas, different parts. The first part, Part A, captures the offense conduct all around, any aggravating or mitigating factors, what role the person played in the offense, if the person accepted responsibility, and anything else, and fashions what would be and conducts its guideline calculation based upon the nature of the offense. I saw that in the chat that Judge Gleason laid out what the Sentencing Commission did, in part in fashioning this horizontal and vertical grid that arrives at a sentencing range. We go through that all top to bottom, including the defendant's criminal history, if anything that he has, offender characteristics, anything about the offender. If one of the root causes or the triggers for the crime were circumstances like Mr. Williams, if the person is addicted to drugs, has a gambling problem, or anything that was a trigger for that offense, and any number of other things, and being able to arrive at the end of the day, a comprehensive report for the judge so the judge can fashion an appropriate sentence.
And I just want to emphasize that this is often like 30-page single-space document as a judge. That's so important to me. I feel like that's how I get to know the person's life from, as Rob said, their childhood, all the mitigating circumstances that could exist, all the different categories, health, family, substance abuse, all those different things can be extremely important in isolation or in combination. In the last few minutes we have, Rob, if you could just talk about the supervision function, if someone gets probation or we haven't mentioned supervised release, but usually if once the person gets released from prison, they're on supervised release usually about 3 years and they'll be supervised. So can you just talk briefly what, I know people have a perception like the probation officer is looking to, for a violation to get the person back in jail, which is not, in my experience, the relationship. Just talk a little bit about what probation officers do in terms of monitoring and what they do to try to help the person, continue to rehabilitate and get on their feet.
Sure. So the probation function over the years, from the time even when I was in a baby AUSA till now, has evolved substantially. Probation, us being a department of second chances, once a person is released from, if they were incarcerated, we receive a pre-release notification. And then what we do through our reentry unit is we conduct an investigation, a background investigation. We go to the location where the person under supervision is proposing to live. We look at the place, the people who live there, the surrounding areas, just to make sure that it is a stable, functioning environment. If the person in a previous time had gang affiliations or things like that, or ran with a crew, we want to make sure that where they're going to is not being populated by those very same people. The goal is to get this person in the right footing from the jump so that they could readjust back to life on the outside and be successful. And so we have a team of officers, many of whom have various specializations. We have people with MSWs, with PhDs, with certificates in various counseling. We have mental health specialists, drug treatment specialists. All of these people designed to figure out what the risks are, what the triggers are that cause the person to offend in the first place, and try to fashion a comprehensive supervision plan for that individual that will not only address those triggers, but also give them the educational, vocational, emotional, mental, psychological help that they need so that they can begin the path of readjusting back to life as a productive citizen and getting to a point where they can self-regulate and self-supervise without the need of oversight. So we have everything from more restrictive forms like location monitoring and periods of home detention in the beginning to everything in between. And the goal is to, in some instances, depending on the offense conduct, starting with a very restrictive form of supervision and having people work their way down along the continuum as they meet certain benchmarks so that we can give them the freedom that's associated with, conducting themselves in a law-abiding way. We have educational imperatives. We have job readiness, skills assessment for those so they can develop the skills to be self-sufficient.
Drug treatment, mental health treatment, all of those various services as well, right?
Yes, absolutely. We have officers who are specialists who will fashion plans where they have them in drug treatment programs, if it's drug treatment. If it's mental health, we have people who need to be medicated and need to be on programs where we ensure that they are medicated and getting the counseling services and the treatment services that we need. So we have treatment service specialists who perform those functions. Now, these folks are law enforcement officers, and if there's a moment in the supervision points where a person is offending and reoffending, and we have to file a violation, bring that before the court, ultimately have that person incarcerated for a period of time or put enhanced restrictions on them, we will. But the goal is addressing the triggers first, getting folks ready first to be successful, and then a law enforcement function on the back end if we need to, because at the end of the day, we are enforcing the court's orders regarding the terms of supervision and standard conditions or special conditions that the judge imposes on a person under supervision based upon their individual characteristics as laid out in the PSR that we talked about on the front end. So the PSR on the pre-sentence side begins what we hope to be the 360-degree process towards rehabilitation and readiness for a productive life once we get past the offense of the conviction and whatever sentence is imposed.
Great. Thanks so much, Robin. I see there's a question. I'm just going to give a real quick response to it. If there's a factual dispute regarding what's in the report, what due process protections you have. There is a process. It's called a fatico hearing. If you object to a fact, you're entitled to a hearing. It's not like a trial. You can use hearsay. So it has some due process protections, but not at the level of a trial. But there is a whole procedure for those types of disputes. But thanks again, Robert. I really appreciate your words.